Hi, everyone. Welcome. I want to say thank you for joining me during this interview series. It used to be called Coffee with Andrea, but I'm changing it to Creative Fuel because what I'm doing is giving artists, designers, and craftsmen the fuel to be able to move their business forward. And of course, we are in Detroit. We are in the Motor City. I came up with that as I was driving in my car, and I thought, what could I call this interview series? Coffee with Andrea doesn't mean anything. It's just me. So how do I express the title so that it engages and kind of gives a better indication of what creatives are going to receive when they listen and watch? So I was like, oh, Detroit, Motor City, cars, fuel. So here we are, Creative Fuel. Today we're going to be talking with a copyright protection attorney who I'm going to introduce in a minute, but I want to tell you a brief story about a client that I had years ago who was so scared that her work, now she was an accessory designer, so she designed handbags, but she was so scared that her work was going to be stolen, it was going to be taken from her online, not the imagery so much, but the design, that she decided that she was not going to sell her bags online. And of course, that's perfectly fine. Anyone can decide where they want to sell their work, whether it's in stores, whether it's wholesale, or whether it's online as well. But the reason that she wasn't doing it was the problem. It wasn't that she made that business decision based on the business model that she wanted to stick with. She made it out of fear. So I worked with her on it and I said, okay, we're going to do our best to protect your designs, but there's really no way to 100% protect you at all times. I said, and think about it this way. If someone comes in and they take your intellectual property, what you created, and they put it online and sell it, because she thought they were going to sell it for way more money than she was selling it for. I said, you're new, you're just starting out. Right now you have no orders and no one really knows you. If they get online and sell your stuff, I said, certainly we can fight that. You can go to court. I said, but think about it this way. If they're getting more money, then you can raise your prices. So it was just like a small consolidation to sway her fear. She ended up actually going online, realizing that the fear was keeping her from making money. And really that's the point. Lawyers their whole world is protection and kind of defensiveness, just to like be prepared, which you absolutely should be, but you should never be so fearful that it stops you from doing something. What you should do is look at the cons and the pros and decide if it's the right choice for you and your business. So think about that. There's so many artists that are scared to put stuff online for that reason. So today, hopefully we're going to teach you a bit about copyright protection and intellectual property and what you should do, what you shouldn't do, and to prepare yourself. So today I want to introduce our Embrace Creatives business member, Anna Robinson. She is a lawyer with Brooks Cushman, intellectual property and copyright attorney. Welcome. I'm so glad that you're here, Anna. Thank you so much.
Thank you, Andrea. It's great to be here.
And I'm very excited to hear. I mean, most of our artists, whether they're designers, craftsmen, fine artists, they want to know how to protect their work. We have some poets here. We have videographers and musicians. It all falls under the arts umbrella, and I'm sure there's different ways to protect. But the first question I want to ask you is why you joined Embrace Creatives and what value do you find from our professional website?
Well, thank you, Andrea. And I think Embrace Creatives is a great platform for creative professionals and business people to connect, and also for creative professionals and artists to connect with each other. So it really provides a great forum that we can use to connect with each other and to inform each other of issues that are important. And that's really important for me as an attorney to see what, I represent artists and musicians and writers, and also businesses to protect their intellectual property. So it's important for me to see what concerns that clients and potential clients have, and things that are relevant to my clients.
Yeah, and recently you actually spoke. the patent office came, one of their stops on their tour, on their world tour.
Yeah, the
Was
copyright office. Yes.
Copyright office stopped at in Detroit, and you hosted a panel discussion, and you asked on Embrace Creatives for, what was it, copyright stories, kind of.
Yeah, copyright stories. Times when either you were very glad that you had a copyright registration, or times where you really wish you would have had a copyright registration.
Right, and one of our Embrace Creative artists actually responded to you and
Yeah.
told the story. So to me, that was really great, and that's the kind of discussion that I want to have on Embrace Creative. Is, you know, questions and answers, and that's why I'm so grateful for experts like you to spend your time on Embrace Creatives, just listening, even watching, and stepping in when you need them, as well as when artists need you. And I want to talk a bit about your background, because you have an arts background, don't you?
Yes, I do, actually. I was a theater performance major at University of Michigan.
Go Blue!
I actually, go Blue! I actually moved out to California, and I acted and modeled for a few years. My claim to fame is I was Magic Mountain's Wonder Woman.
Cool.
For a little while.
Nice.
And then I realized, actually, I was conned by an agent, and signed a bad contract. And I realized at that point, there is a real need to understand these things, to understand contracts, to understand intellectual property. And so I decided to go to law school and learn how to handle those types of issues. And I thought that I could probably use my skill set better as an attorney than as an actor, and I could use both together to then help the creative community in a different way.
That's great. And it kind of sounds a little bit like my path as a fine artist, but with a business background. I started coaching. It's like, okay, I can do something bigger.
Yeah.
And
exactly.
Right. And
I can still sing karaoke.
Yes. Oh yeah. And I still paint, but it's just, you never know where your path is going to lead you, but we're thrilled, and I'm sure it's extremely interesting, but you really, of course, have to have that balanced brain where you really enjoy doing all the research and writing all the briefs, I'm going to say, that you write, and just helping clients in that way. Mm-hmm. So when we were talking, because as much as I know about intellectual property and copyright, 3,000 times more. So intellectual property is like the header, and then underneath are all the subheaders, and copyright is underneath intellectual, is part of intellectual property. So what other intellectual property subheaders are there? And I know I'm using wrong terms, so you will just, you'll use the right terms.
Yeah. So intellectual property is a broad concept that protects the property of the mind. That is separated into 4 different categories. You've got copyright, that protects creative expression in different forms. You have trademarks that protect brand names. You have, and other brand aspects.
Oh, she's frozen. I wonder if we're going to get her back. Let's see what happens.
Hello, hi, sorry, I think we went out again.
Okay. So I'm going to edit that out. So start again with
Let's start again. I want to start again. Okay.
Okay, so you start, because I'll just go ahead.
Okay, 1 second. Okay, so intellectual property is the broad concept of protecting the property of the mind, and that is separated into 4 separate categories. You've got copyright, that protects creative expression. You have trademark, that protects brands and brand names. You have patents, that protect inventions. And then you have trade secret, that protects secret business methods. So today I think we're going to focus mostly on copyright, if that's correct.
Yes, yeah,
so
absolutely.
Protects any original creation that is fixed in a tangible medium, which means you have to either write it down or record it or draw it. It has to be fixed, and it has to be original and creative. Now, the standard is pretty low for that. It just has to have a modicum of creativity in order to be protectable. So most, for example, most fine art easily reaches that level of protectability. The one thing is, functional things are not protectable under copyright. Functional things are protected under patent. So if there are functional aspects, let's say you create a spoon. A spoon is a functional object, so that's not going to be protected under copyright. However, if the handle of the spoon has very ornate carvings on it that could be a sculpture in and of itself, or a creative piece in and of itself, it is possible that that aspect of the useful article could be protected under copyright. But that is something to, especially when we're talking about people who make purses or furniture or useful articles, there is a limitation. Mm-hmm. And something that people don't know about copyright very often is that your work is actually protected by copyright law the moment you fix it. So you don't have to have a copyright registration in order to enjoy copyright protection. Now, what a copyright registration does is it allows you to take it to court, and it also provides you with enhanced damages, which make it feasible for artists to pursue a copyright claim. So registration is important, but your copyright protection affixes as soon as you fix your work in a tangible medium.
And when you say fix, that means finish the work?
No, it just means put it down on paper, record it.
Okay. So it goes from here.
When it goes from here to paper, or to a recording, or to a video. Okay. It is fixed. In a thing that is reproducible, because copyright, copyright is a bundle of rights, and one of those rights is the right to copy. Okay. So it has to be copyable.
Yes.
So that's where fixation comes in.
Got it. So the next question is, I have an original piece, I sell it. Do I still own the copyright if I have transferred the item and we have exchanged and they paid for this? What happens to my ownership of the piece?
Well, that's a very good question. So the default is you still own the copyright. Even though you do not own the physical work anymore, you still own the copyright. I like to compare it with a CD. So you go to the store, you buy a CD. You don't own the copyright in the songs on the CD. You own the physical CD, and you have the right to play the songs on that CD, but you don't have the right to reproduce that CD and sell it, or simply reproduce that CD. It's the same thing with artwork. So if you sell a piece, the person you sell it to does not have the right to copy that piece, does not have the right to publicly display it without your consent. So, but at the same time, that's the default. You are able to contract away from these rights. So that's an important thing to think about when you enter into an agreement. You want to say, okay, you want to make sure that an agreement doesn't assign your copyright.
Right.
Or if it does, you have to, you should be reasonably compensated for that.
Right.
Another thing you have, in addition to copyright, you also may have some rights under VARA, the Visual Artists' Rights Act, to prevent the person who purchases and holds your artwork from destroying it, or from doing anything that would negatively impact your moral rights. And that's only for a very specific subset of work, though.
Yeah, and actually I was thinking about destruction. So from an artist side too, I want to tell artists that although you own your copyright and you can make copies of that original work to sell, I'm telling you that it's really the right thing to do is to contact the owner of the original piece that you've sold to ask their permission. And to me, that's more of a moral thing rather than a legal. I don't know if Anna will tell me that I'm wrong, but if I purchase an original and I see that work being sold almost verbatim because it's a giclée or it's a limited edition print, you know, and I purchased it, I don't know. I would be upset if I was not told by the artist or knew beforehand. So Anna, what do you think about that?
Hi, I think our video went out again.
It did, but I was
Yeah.
talking, so it was fine. Did you hear what I said?
I heard a little bit and then it stopped. You mentioned that the best practice in the industry is to contact the person who purchased the art to let them know whether or not you're
You're
going
going to
to
reproduce it.
copies of it.
Yeah.
Now,
And do
there's
you agree?
no unless you contract otherwise, there's no legal requirement that you do that.
It's kind of more
But
moral.
it's best practice in the industry,
Yeah.
and that's a very important thing to consider too. Not everything is legal, black and white. Sometimes you have to look at what the industry standards are and also respect those.
Right. And respect your client because it is a
Yeah.
relationship that you're building. And, you know, you don't want them to say, oh, I purchased this piece and the artist is selling it out from underneath me, or a gallery. You know, you have a gallery sells an original and then they find out that you're selling reproductions. That lowers the price of that could lower the price of the original. So just think about that before you start reproducing your own work where you've sold an original. The next question, I wrote these questions down because these are so important and so specific, where my other interviews are kind of like free flow. This one, you know, Anna and I wanted to like be on point and give you the best information as possible. So the next question is, what are the two most challenging copyright issues artists and designers face? Can you name two?
I would broadly group them into protection and enforcement.
Okay.
I think the internet has really been a game changer for copyright artists specifically, for both protection and for enforcement. Um, so regarding protection, you know, when you put your work on the internet, it is very easy for people to right click or to people to screen grab or for people to take it and copy it. And most of the time they don't.
Hi. I'm wondering,
Sorry.
I'm wondering if it's your video. Should we, should you, not that I want you to turn off your video because I don't want to just hear you, but what do you, oh, you're mute, turn on your,
Wait, so there. Is
okay,
that good?
perfect.
Yeah, okay.
I guess should we just keep
I don't
trying?
know. I don't know why it's being so laggy. I mean, I have like 5 bars. I'm on Netgear, 5G.
Yeah.
I don't know.
Well, we'll keep
I
trying.
could
I'll
try,
just,
I could try it. This might, should I try another? Because we have like 4 different lanes for the internet at our house. I
oh,
could
okay.
try another one. Let me try this one. I might disconnect and then reconnect with you, but
Okay.
let's see.
Well, I'm keeping the recording going, so I'll just remove anything that we don't use.
Let's see. Is this?
I mean, we won't. No, now you stalled again.
I don't understand what this question was that this thing just popped up.
Oh, I didn't see anything.
Okay, is this better?
I guess we'll just see. I think it's
Yeah,
just, is it okay?
I think so.
Okay.
So sorry, I was going on and on and on, and I realized you were frozen.
It happens. You're frozen. All right. So I'm going to ask it again. At the beginning of the video, I'm going to say we had challenges, so it may not be smooth. Okay. So we'll start this question again. What are the two? Wait. Let me start again. What are the two most challenging copyright issues artists and designers face?
Well, I would group those broadly into protection and enforcement. So the internet has really been a game changer. As you know, it's very easy for people now to just right click or screen grab and take your work off the internet. And often people aren't doing it maliciously. They don't know. They assume that because something is on the internet, that it is public domain. And that's not true. Public domain has a very specific legal definition. It means something, usually a very old work that no longer is protected by copyright. But that's not what posting on the internet does. It does not mean that your work becomes part of the public domain. You still own the copyright in that. And there's just wide misconception that that's not the case. So an important thing to do is to think about protecting your work before you post it on the internet, before you make it so accessible. You can file a copyright registration, which gives you enforcement power. And it's very reasonable to file a copyright application. I mean, the government fee is about $35 if you are the artist and you are the claimant. So that's one way to do it. There are other ways to protect your work, or at least to provide notice that you own the copyright. Putting a copyright notice that has the copyright Circle C symbol, the year that it was published, and your name. Putting that notice on your work, or putting that notice, nearby, helps people to realize, oh, this is something that's protected by copyright. And then if somebody removes that under the Digital Millennium Copyright Act, you have another cause of action against them if they remove a copyright notice. Mm-hmm. So those are some important protection mechanisms. Other things you can do, you can add a watermark or something like that. That's just another thing that makes it less likely somebody's going to screen grab because they don't want an image with a watermark on it. That's more of a deterrent than really a legal protection. And enforcement is the other part of this. So if you are going to be posting your work on the internet, you have to be diligent because there's no such thing as the copyright police. You have to be your own copyright police, which means you need to diligently check the internet for unauthorized uses. There's software that you can use that will comb the internet for these types of issues. And you can send, cease and desist letters. Have an attorney send a letter saying, hey, this is my property or this is my client's property, please remove it. You can correspond with them yourself, or, can get a big scary attorney letter, a cease and desist letter, that we're happy to help you with enforcement. But it's very important to remember that nobody's going to protect your copyright for you. You have to be vigilant and you have to be on the lookout for infringement.
Yeah, that is really true. I mean, when you're running your business, you have to be in control and do the best you can to monitor what's happening with your own business. If you just kind of let it slide, then, bad things can happen anywhere in your business, but especially when we're working with images and we're working with audio and visual, you have to be diligent. One thing I want to say is that on Embrace Creatives, I have installed a plugin so that you cannot right click on an image. It will come up and say this image is protected. So everyone on Embrace Creatives, no one can right click. That doesn't mean that they can't screenshot, but no one can right click your image away. So I made sure to protect the artists on my site because I am an artist and I know how important that is. And I also, in my fine print and the terms and conditions, it says you own unlike, I guess, Facebook, who says they own all of our images, you own your stuff. I'm just the host. It is yours. It is your copyright. I do not own it just because I'm storing it digitally on Embrace Creative. So yeah, I'm really here for the artists and want to make sure that they feel protected and that they trust me, because all I want to do is empower you. So yeah, right click protect to me was one of the first things I did, because I felt it was really important.
Yeah, Andrea, you bring up a really good point with social media and terms and conditions. That's another aspect of the internet that's important. Before you post your artwork on Facebook, Instagram, other social media, Embrace Creatives, other platforms, make sure you know what legal rights you are giving to that platform.
Right.
Where I don't think Facebook actually says they own it, but Facebook does give themselves an unlimited worldwide license to use whatever you post.
Okay.
So you're giving Facebook a license to do whatever they want.
Right.
Obviously this may be a little broad. It may be more limited than that. I have not read the Facebook terms and conditions in a while.
Most people
but it is likely still a very broad license.
Yeah.
And that's to protect them, because they want, people to be able to post and share and, and things like that without limitation.
Right.
The other thing to be creative about, to be important the other thing to consider is when you are using somebody else's work. And we can talk about that's the flip side, that, let's say you want to make a collage, an artwork that's, uses other media and other people's artwork. You have to be very careful with that. In some circumstances, that can be considered a fair use if you are creating something that's transformative. Mm-hmm. But fair use is a very fact-specific analysis. So you do have to be very careful when you are using other people's artwork, or you are inspired by other people's artwork to create your own. Mm-hmm. The best practice is to get a license. If you're going to be using somebody else's work and incorporating it in your work, to get permission from the person in writing that you are allowed to use their work to create another work. Because the right to create a derivative work is in the bundle of copyrights. So as the copyright owner, you have the sole right to create derivative works of your work unless you license that right to someone else. Yeah. The exception, again, is fair use, but that is, you don't want to find yourself in the position of relying on fair use, because it is a defense to copyright infringement.
When I worked at a jewelry store, when I lived in New Jersey, clients would come in to buy beads. It was actually a bead store. And they would come in to buy beads, and they would come in with a magazine and say, I want to make this exactly. And I'd say, no, I wouldn't allow them to, even if they were just making for themselves. I had no assurances that they weren't going to sell that piece. So I said, how about this? As an artist, that's what artists do. You can be inspired by this piece and we can use the techniques, but let's make it your own. And then I would work with them to change it so that it was theirs and they weren't copying verbatim. And I'm not talking about a how to make article. It was an interview with an artist and they would show their work, and this artist wanted to create that piece that artist made either to wear for herself or to sell. And I put the kibosh on that. I was like, no, I mean, I couldn't allow them to do it. So yeah, using other artists' work as your own is, or yeah, something that, I mean, we shouldn't do
copyright
anyway.
Infringement. And it's actually better for you as an artist to create your own unique work that's protected by copyright,
right?
Rather than to copy somebody else's work,
right?
Because you don't have any protection in that; it's not yours.
Exactly, and that's another reason I was telling the artists no, because it was teaching them to be creative in your own right. Mm-hmm. So we talked about watermarks. I hate them. I think they're horrible. They ruin the image for me. I understand they're a deterrent, but I've heard from digital artists that they can be removed very easily. So, you know, I've seen artists on Embrace Creatives use a watermark. Is there another way to deter rather than a watermark? Or, you know, I find that it just takes away from the work for me. And if I'm looking to purchase, if I'm looking as a buyer, either to purchase or bring you, you know, into the exhibit that I'm curating. It's just, I hate them. So watermarks.
You're not alone. Actually, most artists I talk to, this is another thing, you know, about just the um, industry standards, right? Artists don't like to use watermarks, and there's no requirement that you have to, and there's no legal benefit to do it, other than, you know, it can be traceable, you know, to say, okay, I know this is my work, because especially for things like photographs, that sometimes it can be difficult to prove when somebody's modified a photograph that the original photograph is your photograph. It really, especially because it is easy to remove, there is limited benefit to it. I mean, what it's going to stop is going to stop your, you know, low level person combing the internet for an image that they want to stick in a PowerPoint or they want to put on their website. Because those uses, they're probably not going to be sophisticated enough to know how to remove the watermark, so they won't use it. But if you're talking about, you know, sophisticated people who want to use your work, it's not going to stop them. Right. You know, like I said before, a good thing to do is a prominent copyright notice that at least tells people, look, this is my copyrighted work. You are not allowed to copy it without my permission. And also, if they remove it, there can be statutory damages under the Digital Millennium Copyright Act for that removal. So a copyright notice and you don't need to have a registration to put a copyright notice on your work. Like I said in the beginning, copyright exists the second you fix your work in that tangible medium, right? So you don't need permission to use a copyright notice. You absolutely should put a copyright notice on everything you do, because it's a do not trespass sign.
Right.
So that's what I would recommend. And then, you know, another thing, if you get that the copyright registration, and you send a cease and desist letter with a copyright registration attached to it, that is a much more serious issue. The person receiving that copyright cease and desist letter is going to say, or any attorney they work with is going to say, this is serious. This person can potentially get statutory damages, which means you don't have to prove the amount of money for the claim. You actually there's a statute that says you can get up to $150,000 per infringement if it's willful. So per work infringed if it's willful. So there are some very specific, very serious consequences if you have a registration. So it can make your enforcement much stronger and much more effective.
Right. So artists, think about that before you stick a watermark on something. Because I'm glad that you cleared that up, because
put a copyright notice. Yeah. File a copyright application
rather than that huge watermark in the front of something. Before we move on, we have a couple questions left. I just want to tell everyone that Anna's going to be creating a series of blog posts on copyright protection for us. She's a very busy attorney. She will get to it when she can, but we're going to look for it, and I'm honored and really excited. And the other thing is, Anna, I posted something and tagged you because there's mural artists. I don't remember where they're located, and they sued a large corporation because they use their mural in advertising, without the permission. So I tagged you in it. It's just another copyright protection debacle.
Yes, it's very, very, very interesting. That actually is fairly common. That's another example of even businesses not understanding copyright and thinking, oh, well, this is, it's a mural on a building. I can take photographs in front of it. That's still artwork.
Right. Or their lawyers know, and they think, well, this artist isn't gonna, how many artists are actually going to hire a lawyer and, do whatever they're going to do. So some businesses just take their chances because they have
they do.
On them. Yeah. And so speaking about that, moving to the next question, if an artist or designer sees that their work is being used without their permission, what can you list, like maybe the 1, 2, and 3 steps that they should be taking to, they're like, oh my God, this work I see it. It's online. It's not mine. Someone else is using it. What do you suggest they do?
Well, first thing, document it. So you want to take a screenshot of the infringing use and save it and date it, because you want to have that record that of it, because things can change, people can take it down, and that's the other thing. If someone takes it down, doesn't take away the copyright violation. So you can still, if somebody could have something up and take it down, they have still violated your copyright. By taking it down does not remove that violation. So you want to document it, number one. Number two, you can reach out to them, tell them to take it down, and tell them to compensate you for the use of the image. Now, you're going to have a much stronger argument if you have a copyright registration, because you have those scary damages you can leverage. But even if you don't have a copyright registration, you can write to them and say, look, this is my artwork, please take it down. They may just take it down and not pay you, and then it's up to you to determine whether or not you want to take further action to try to get a license for them to use the image. That's the other thing. The answer doesn't have to be take it down or else. The answer could be pay me a license. You can use my artwork. I just want you to use it with permission. So it doesn't have to be that black and white. Another thing you can do, if they refuse to take it down, or if they are, being difficult with you, you can also, under the Digital Millennium Copyright Act, send a takedown notice to the internet service provider. So let's say you see it on a Facebook page. You can send Facebook a takedown notice using their form, or sending it to the address in the terms and conditions that you're supposed to send these copyright notices to, and you can have them take it down under the Digital Millennium Copyright Act. Now, it's a specific process, and there's a counter statement they can file if they don't believe that it's actually a counter notice. I'm sorry, if they don't believe it's actually an infringement. But that's another thing you can do. There are ways to take it down, and an attorney can help guide you through some of these things too. But document it, ask them to take it down, or give you a license. If they don't comply with you, contact the internet service provider and give them the information needed for a takedown notice. Now, that's something you could look up online. You can look down, takedown notice, because there are specific things that have to be in this notice for the ISP, the internet service provider, to take it down. If it's a website, it would be the company that's hosting the website that you would send the takedown notice to. And again, you'd have to make sure that you cover all of the things in the statute. You have to have various statements.
Cover all your bases.
Yes, exactly, for it to be a legitimate takedown notice, and for the internet service provider to comply with it, or you need to have all those things. And the reason that they are so willing to comply with these is because if they don't, then the website itself, or the internet service provider itself, or the platform itself, could be liable for copyright infringement just by hosting that infringing work.
Interesting. And maybe what you can do is when the articles are ready to be put up, maybe there can even be like 1, 2, or 3 resources, links out, because it's digital, just to that takedown notice, or to that basic copyright form, something like that, so that artists can kind of easily get where they need to go. And these aren't by state; these are federal, correct? So it's not like
copyright is federal.
Okay, good. So we don't have to worry about all the different artists in all the different states on Embrace Creative. So this is wonderful. And and it can get scary thinking about all of this. And we don't want artists to be like totally freaked out. Oh my God, I got to protect everything. It's really, so much of it is being proactive and just again being in control of what it is that you're doing. You cannot protect everything at all times, but what Anna does is allow you to just feel a little bit calmer, and that you do have options. You do have options available if something like this happens. It probably happens to a very small amount of artists, but because it's in the news and because it does happen, we see it, we hear it, and we think, oh my God, it's going to happen to me. And it could, but you can't live defensively. So let's, with Anna's help, just keep you very calm, but protected and sane. So just, don't freak out. Don't freak out from it.
And there is obviously we talked about copyright today, but there's other ways to protect your work using intellectual property as well. You can protect the name of your gallery with a trademark. You can protect the design of a purse with a design patent. You can, protect an invention with patent. You can keep some method that you have in your business a secret and protect it under trade secret. So there are many different ways,
right,
use other intellectual property in addition to copyright to protect your work.
Right. And if anyone wants to get a hold of Anna, so she's on Embrace Creatives, and you could speak to her if you have a specific problem. For general questions, you can certainly, write to her on Embrace Creatives, but wait for she's gone. Sorry. Wait for her articles, because they will probably answer a lot of questions that you have. I hope that Anna comes back on. We've been having issues today with connectability. So if she doesn't come back on, I'm sorry. It was great having her. Loved it. Anna Robinson, she's a business member on Embrace Creatives, intellectual property attorney with Brooks Cushman here in Michigan. I'm Andrea Bogart. I'm the founder of Embrace Creatives. I'm very happy that you are here with us today for Creative Fuel. Please join Embrace Creatives. Share this interview. It's really important that we empower as many artists as possible. And come on in and join us on Embrace Creatives. So happy to have you. Again, thank you so much. And I'll see you the next time on Creative Fuel.